live now.
Good afternoon, everybody. We'll resume the public inquiry. We're now at the stage where we're hearing the second witness of the appellant, namely Mr. Armstrong. So I'll allow Mr. Cannock to introduce Mr. Armstrong, and then once the examination in chief has occurred, I'll ask Mr. Wilcox if he has any questions he wishes to put to Mr. Armstrong. I see I've been supplied with some documents. We'll go through those in due course, but I suspect they're the schedule of conditions and the section 106.
And the compliance statements.
Thank you very much. I'll number those in due course. I'll give those inquiry document numbers in due course. So I'll let Mr. Cannock carry on with his examination in chief.
Thank you, sir. Mr. Armstrong, let me introduce you. Your name is Jeff Armstrong, is that correct?
That's correct.
And you hold a Bachelor of Arts Honours degree in Town and Country Planning. You're a member of the Royal Town Planning Institute. You're a Director of Armstrong Rig Planning. And you have 38 years planning experience, is that correct?
Yes, that's correct.
And prior to establishing Armstrong Rig, you worked for a number of local authorities, including London Docklands, Runnymede, as well as DPP, where you were an Executive Director, is that correct?
That's correct.
You've visited the site, you're familiar with the locality, and you were instructed in January 2022 to act in respect of the application, is that correct?
That's correct.
And you tell us that your evidence is true to the best of your knowledge and belief, is that correct?
It is indeed, yes.
I'd like you to start, Mr. Armstrong, with just a point arising out of the evidence of Mr. Milcreast. Mm-hmm. So the application, we know all matters reserved save for access. Access means the points of access. And so accordingly, what this proposal needs to do is to demonstrate one way in which what is proposed can be appropriately laid out and addressed through the reserved matters.
Correct.
Now, the first thing to probably just touch on is in terms of design, if you turn to your Appendix 2, we in fact have a design technical paper, don't we?
We do, that's correct.
Okay, well, I don't need to go anything further through that, but that sets out a summary of the design process and how high quality design can ultimately be delivered through the reserved matters, is that correct?
That's correct, yes.
And then the inspector wasn't making the point, respectfully, was asking questions about the nature of the application and what may be secured by conditions and through the reserved matters application. If you could turn, please, to the statement of common ground at 3.8.
Yes, got that.
And if you could also have to hand CD 2.7. Sorry, that's not right. CD 1.27.
Yes, I've got that.
And effectively, when the application was submitted, it was submitted with a framework plan, and that framework master plan was a plan for determination.
Correct.
And that included the areas of built development and the areas effectively of open space, is that correct?
That's correct.
What we might think of as a parameters plan. And the local authority stated that they didn't want that as to be a plan for determination. They thought that it could all be dealt with through the reserved matters application.
That's correct.
Okay,
yes.
I'm effectively just summarising what's in the statement of common ground. Right. So if we just take it in stages, firstly, can the reserved matters appropriately secure a design which sets out the built development and the areas of landscaping and the high quality landscaping that we have discussed? Is the reserved matters adequate to do that?
Yes, it's for the council as the local planning authority to take the information contained in the outline and then secure the open space, the buffers, the landscaping through the reserved matters.
If, however, it was considered to be necessary to secure those particular parameters. Firstly, could the framework master plan be considered as a plan for determination, bearing in mind its formal submission?
Yes, it could, and as I said before, that was our original intention, was for this plan to be conditioned as part of the outline for compliance with the RM in the future.
And if then there was to be a condition which required the reserved matters to be submitted and determined in accordance with the framework master plan and the landscape strategy, what's your view as to whether that would then secure those parameters and effectively mean that the detailed points that Mr. Milcreast was addressing are the correct factual basis on which to assess the proposal?
Yes, it would provide the clarity for what the reserve matter was going to be in the future. It would clarify the delivery of the landscape buffer, which we've obviously spent some time discussing and providing evidence on. So it just gives that extra security that these key points are delivered as part of the RM.
Thank you. Right. So let's start, please, with your evidence at 2.7. And we see then that there was a recommendation for approval, and it's agreed at the times of the determination there were no outstanding requests for further information, no objection from statutory consultees, a recommendation from the officer endorsed by the director. What weight do you say should attach to that consensus of professional assessment?
I think that should have significant weight. It was the processing of the application with the officers, the pre-application discussion we had. Clearly the DM officer had discussion with the policy team, and we'll come back to that later. But clearly the determination, the recommendation for approval was one which the officers thought long and hard about. They just had their 5-year supply removed, and so they had to look at, were there any sound reasons for this site to come forward to be recommended for approval? And the report clearly sets all those issues out and should be given due weight accordingly.
Next, please, if you look at your 2.9, the reason for refusal, beyond the location outside the settlement boundary, what other reason is given for refusal?
None. It's clear that is the crux of the matter in hand.
Okay, and so what you've referred to, and my learned friend picked up on it in opening, is this use of the term, well, there is a technical conflict with S1, S2 and S8.
Yes.
What do you mean by technical?
What I mean by technical is that it's that one particular issue which flows through the policies. So in other words, there are other component parts to those policies, but the conflict stems only from the fact that we're developing outside the settlement boundary, not, I say, from any other limb from those particular policies.
Yeah, is there any land use consequence, land use impact which flows from the location outside the settlement boundary?
No, there isn't, no.
No. By using the term technical in that way, there's no land use consequence which flows from it. Are you suggesting, tell us, that somehow technical means, well, not really something to be taken seriously, the conflict with the development plan?
I think it's the way we've presented it is on the basis that it's we acknowledge that there is a breach of the policies, so we're not trying to suggest otherwise, but in terms of the scale of the breach, the fact that it's a technical or part of, or maybe there was a better phrase we could have used, that it wasn't a series of conflicts stemming from various elements of those particular policies. It was just that one particular aspect of putting a development site outside the settlement boundary.
Okay, so let's maybe try and do this without reference to some documents if we can. The development plan, I'll assume a large amount of knowledge if I can. The housing requirement in policy S2 is 310 dwellings per annum.
Correct.
What was the basis of the uplift from 294 in the draft to 310 in policy S2?
The uplift was twofold. One was to deliver the employment opportunities which the council were looking for, I think in the region of 2,000 jobs. And the uplift was also linked to the affordable housing provision.
And does that minimum requirement of 2,000 jobs to 2029 in policy E1, is that extant or not?
No, it's still current today.
And so what reason, if any, is there to reduce the housing requirement to 2029 as a minimum?
No, I think that the 310 is still the target set in the local plan, and is still the target which the council need to be in place to meet their very strict objectives which they set when they adopted the plan.
And so if I look, please, at policy S2, so CD 3.1, policy S2, it's page 18.
Policy S2.
Yes, please. It's page 20 of the PDF.
Yep.
And that then identifies a supply of 5108. And if I look at the table on page 18, page 22 of the PDF, what are the sources of the supply?
The sources are the allocations and those neighbourhood plans which allocate sites and a windfall allowance of 300. So it's a very specific makeup of that housing requirement.
And if you were to just be sufficiently interested to scroll to the glossary and the definition of windfall, I'll just read it out. So it's page 138 of the PDF. It says windfall sites are sites which have not been specifically identified as available in the local plan process. They normally comprise previously developed sites that have unexpectedly become available. So with that limited windfall allowance, what was envisaged by the plan? What would be the source of that windfall allowance?
Well, the source would have been PDL sites within settlement boundaries.
Yeah. And so with that in mind, if you look at 227 and 2.29 of the plan, so 2.27 and 2.29, what is the spatial distribution of housing as planned?
Well, spatial distribution is focused on the three key urban areas, and that the council have focused on from day one.
And in 229, what was planned in terms of growth in the rural villages?
Very limited. It was 300 in total.
And so what then is the role of the settlement boundaries in the context of that spatial distribution of housing?
Well, the settlement boundaries then are very rigid in the way they are seen in terms of these policies, and any development which would be outside of those settlement boundaries would be open for the council to resist in terms of the way these policies are actually presented.
And then in terms of policy S8 on page 50, I see the settlement hierarchy and the categories. And what was the evidence base at 2.104 for the categorisation of the settlements?
It was the 2.14. There are three documents referred to there. So one with the district rural facility survey is included in there.
Okay. Now, the plan then was examined and found sound post NPPF 2012.
Yes.
So what conclusion did the inspector reach about soundness, one of the tests being consistency with national policy?
Yeah, the inspector, on the basis of the evidence provided, found that although challenging, was happy to effectively sign off the plan as sound.
Okay. And do you challenge that conclusion?
No, I can see what the council were trying to achieve. I understand what their aims and objectives were and how the policies are worded accordingly.
So then if we just look briefly at compliance with the development plan, please. So compliance with the development plan, policy S1-2 on page 18. Is the proposal in one of the most sustainable locations being the 3 main settlements?
No, it isn't, no.
Is it PDL or growth at the garden suburb or the strategic allocation?
No, it's not.
12, maintain the rural character without compromising the identity of its individual settlements. Looked at this with Mr. Milcrease. Is there anything that you wish to add to that?
Not specifically. I think the issues were covered. I mean, I would endorse his comments that I don't believe that there is harm for that particular strand of S1B or S1B. I mean,
Okay, and then S2 and S8, we agreed with Mr. Coleman that we interpret and apply together.
correct.
And just in terms of S2, first of all, any evidence of harm to the spatial strategy or the LDP approach?
No, I've seen no evidence that we're in any way going to prevent the council's preferred locations to come forward.
Beyond harm to the identity of the settlement, is there any land use harm which flows from the conflict with the spatial strategy claimed by the council?
No, there's no.
And then if one looks at policy S8, we're located outside the settlement boundary, in which case there are 2 points, both of which need to be met. The first is the intrinsic character and beauty of the countryside cannot be adversely impacted upon. Do you recall I asked some questions about PPS 7? How consistent is that approach with what was formally set out in PPS 7 and protecting the countryside for its own sake?
It follows the same lead in the sense that there is no flexibility allowed for other circumstances to come into play or other benefits to be taken on board when looking at judging the harm to the landscape area.
Is that policy approach consistent with what we see in paragraph 180A and B of the NPPF, which is drawing a distinction between designated landscapes, valued landscapes, but recognising the intrinsic character and beauty of the countryside as appropriate?
That's correct. Yes.
No, sorry. Is what's set out?
Oh no, sorry. No.
Is it consistent or not consistent?
No, it's not consistent with that.
Okay, but can you understand how the inspector found the plan sound in circumstances where he was being told, well, we don't need any housing outside settlement boundaries?
Yes, as I said before, I can understand how the policies are worded the way they are, given the council's objectives, which were set out some years ago.
Can a scheme of market housing ever comply with the exceptions in policy S8, so criterion A to M, unless it's allocated?
And no, it can't.
Can a mixed scheme of market and affordable housing delivered, the affordable housing being delivered by the market housing, can that comply with the restrictions?
Not a mixed scheme, because it limits it to rural exception. So whether there is any market in there is maybe possible, but I think it's highly unlikely.
So is there conflict with S2 and S8?
Yes, there is, yes.
Is there conflict with the development plan as a whole?
Yes, there is, yes.
But in reaching that conclusion, what scope is there to consider the need for the housing? Can you consider, or are you required to consider the need for housing in reaching the conclusion that there's conflict with the development plan?
No, the wording of the plan and the policies is such that it doesn't enable that to happen. But clearly, the case office, when looking at this application, then went further, went beyond what was in the policies, and did that very exercise of saying, well, where are the harms, where are the benefits, etc., etc.
And again, I'll wrap these questions up. Can I take account of the accessibility or the sustainability of the site, the economic benefits, the actual landscape and visual impact, or any form of planning balance in reaching the conclusion that the proposal is contrary to the development plan?
Are they allowed within the policy?
Yes.
No, they're not. No.
And so does this development plan allow for a balanced appraisal of this development?
Strict interpretation, no, it doesn't.
And in terms then of the success or the performance of the plan, could you turn to your appendices, please? And your Appendix 1, which is the Emery technical note.
Yes.
And if we look at 5.2 on page 15, how successful was the plan in being able to demonstrate a 5-year supply?
Well, it wasn't very successful at all until the situation changed last year. So it was getting worse. It went from 4.9 down to 3.66.
And if one looks at the completions, please, on page 11, table 4.1.
So what page is that, sorry?
Page 11. Black 11, yeah, sorry. Table 4.1.
Yes.
So we have the completions, and we agreed with Mr. Coleman that performance was not very good in the first 5 years. But then what in fact happens if we think about March 2020 as being the start of the pandemic? What actually happens in terms of delivery during the years of the pandemic?
Well, it actually improves.
And so as to the contention, well, you tell me, why was there such a shortfall in housing in the first 5 years of the plan? And why do we see, if we turn over the page, a 914 unit shortfall against the housing trajectory? What's the reason?
Well, the reason is that the allocated sites weren't delivering. They were slow in delivering, which I think is an agreed position.
Yeah, we see that at table 4.3. We
Yes,
see a shortfall of 910 on the allocated sites.
And obviously with the council having a sub 5-year position, there were greenfield sites on settlement boundaries were being submitted at that particular point, making 30-odd% of the total number of houses coming forward. And I would imagine that they would be reflected in the 3 years from 2019 up to 2022, 2023 as well.
Yes. So does the performance in the first 6 years of the plan, that being problematic, can that be explained by the pandemic?
No.
What we then see, if you turn to black page 14, table 4.4, Mr. Coleman was keen to point out that performance has been better more recently. What's the explanation for, at least in part, for the better performance in the last 5 years?
With the windfall greenfield sites coming forward on the back of the sub 5-year position.
So if greenfield sites can come forward in the pandemic, what explanation does that provide, that it's the pandemic which is causing the strategic allocations not to come forward?
No, it was the allocations themselves which were delayed in coming forward, not due to any particular outside influence.
So what we have then is a plan which wasn't able to demonstrate a 5-year supply, the minimum requirement of policy against a minimum housing requirement.
Yes.
A shortfall against the minimum annual housing requirement.
Yes.
And a very significant shortfall against the housing trajectory.
Correct.
And delivery being propped up by greenfield sites outside settlement boundaries.
Correct.
Pause there. How successful has the plan been to date?
I think that the plan has failed at this particular moment in time to deliver what it should be delivering at this moment in time. And I think Mr. Coleman acknowledged that yesterday, that there is a failure in the plan to deliver where it should be today. I think the difference between ourselves is Mr. Coleman is hoping that the non-delivery of the allocated sites will improve to be able to then meet the shortfall for the next few years. I'm not necessarily convinced that is the case, and sites like this are sites which will ensure that the council are able to deliver what their aims and objectives were in the local plan originally. It's obviously that was part of the thinking why the officers recommended approval for this site in the first place.
Okay, and previously then, so 2 points. Firstly, you've previously identified that you agree and accept that the inspector found the policies were consistent with the MPPF. But the second point is, if, respectfully, this inspector finds that the policy approach and the spatial approach is too restrictive and is failing to deliver as planned, and is therefore failing to meet minimum needs, how consistent is that planned approach with the MPPF imperative to boost significantly the supply?
Yes, the inspector is perfectly entitled to look at the issues in hand and actually decide that whilst there is some conflict with the policies, the overall benefits, the material considerations would weigh heavily in favour of the scheme being approved.
Okay, and we look then at the statement of common ground. What's the agreed position in terms of the local authority's position on the need for a review and an update of the plan?
Well, they've agreed it, and they are in the process of starting to do that review.
And if we then look, please, at CD 5.9, so CD 5.9, so this is the briefing to the Overview and Scrutiny Committee on 5-year supply. We looked at this briefly yesterday. Could you find, please, 5.5 on page 8 of 13?
Sorry, did you say 5.9?
5.9.
5.9, sorry, I went to all. Yep, got that. So paragraph.
So 5.5. What is the explanation provided by this officer as to why the local authority has failed to deliver as planned and failed to deliver the minimum housing needs against a minimum housing requirement?
Yes, we went through them yesterday, but they're set out a series of bullet points here which explain the failings of the plan, and that involves the lack of windfall allowance, the wording of the actual policies themselves, the strict settlement boundaries which basically squeeze out development opportunities, and the settlement hierarchy which is out of date, not robust enough, and again doesn't reflect what the realities of the situation is.
And what suggestion is there in this report from a technical officer specifically looking into this issue in 2022, so just as we're coming out of the pandemic, what suggestion is there that actually it's all down to the pandemic?
No, there's no reference to that at all.
Right. And so how consistent then is the analysis in 5.9 with the evidence that we have seen in terms of delivery at the start of the plan period,
yes,
and then through the pandemic years?
Yes, I think that the findings of this report mirror the findings of the evidence which we put forward today in terms of the failings of the report, and how it, in essence, the plan, unless there are changes and applications are dealt with in a different way, certainly this policy officer was of the view that the plan wasn't going to deliver, and obviously that then fed through to the DM officers when they were writing their report recommending approval on this application.
Material considerations, please. The first one, need for market housing. We agree a 5.97 year supply, correct?
Correct.
If you turn in your appendix, please, to page 21, we see that that is a supply of 1665.
Yes.
Of which 620 dwellings, this is 533, 620 dwellings, 37%, are windfall sites.
Correct.
So how consistent is the current component of the 5-year supply with the plan?
Well, it's inconsistent as it's relying on non-identified sites to come forward to top up the supply.
And if you turn on, please, to 5.35, we see that 523 units, 31% of the supply, are on windfall sites located outside the settlement boundary. So why is it that this local authority can demonstrate a 5-year supply at the moment?
As a direct result of the windfall sites being approved.
And if one looks then, please, at table 5.5,
Yes.
if we just look, this is the future 5-year housing land supply position based on the council's trajectory. Do you see that?
Yes.
If you just look back at table 5.3 on page 21, do you see the council's position was 6.67 years?
Correct.
Okay, we now agree it's 5.97. So in fact, the starting point should be 5.97, not 6.67. But it doesn't matter for the broad point is, based on the council's trajectory, what is going to happen to their supply of housing?
It's going to reduce. So they've had their opportunities via the 5-year supply and the change to the housing requirement to 279. That's obviously improved matters in a short-term way, but what this plan is showing is that the housing numbers will then start to reduce.
And then 6.1 then, this is the supply across the plan period. We agreed yesterday a residual of 1969 to 2029, from which we deduct the 1665 to get a residual of 304. So 304 homes still need to be delivered between now and 2029.
Yes.
What does the local authority need to do to meet that minimum requirement, to meet minimum economic housing needs? What does it need to do?
I think they've got to take some proactive stance to change the way they deliver their housing numbers.
But where are they consistent with what has happened through the pandemic years, consistent with the components of the existing 5-year supply? Where are those sites going to have to be consented?
I think where appropriate greenfield sites come along, then the council need to take a proactive view on considering approving those to further improve their supply. Because clearly that was one of the comments on from the scrutiny committee was clearly you need to keep adding to the supply to ensure that you're able to keep that supply at the level where it should be. So it needs to be more proactive based on the experiences which are set out in this note and in the rest of our evidence. There's a clear pattern for this particular local authority, and I believe officers are aware of that and are trying to put that right and are trying to improve it.
Second point, need for affordable housing, large measure of agreed evidence.
There is.
Evidence of Mr. Roberts is not contested.
Correct.
So just looking then at the need for affordable housing, what has been delivered? I'm not going to go through this again. What the future supply and issues of affordability, how would you characterise the position in terms of the need for affordable housing?
I'd categorise it as acute, a crisis, whatever. The council are inevitably going to fail to deliver what they said they were going to deliver in terms of affordable housing numbers. That's not, in my mind, an opportunity then to just put your hand up and say, well, we're never going to deliver it, therefore we'll just won't do anything about it. Clearly the evidence we discussed, and I don't think there's anything between ourselves and Mr. Coleman, is that there is a huge unmet need out there for all ranges of tenure for affordable, and it's only going to get worse. I mean, you just listen to the news every day. It's going to get worse, and to put your hope in the delivery of these allocated sites, who may come back in and actually look to reduce the affordable number. That has happened on the larger urban extensions in this authority and other authorities. So they may not actually get the affordable which they think they're going to get from the large urban extensions in any event. So an opportunity of a 50% scheme coming forward, I would certainly say substantial weight is the minimum almost to attribute to it.
Yeah, and I think that that's agreed. Third issue, the need for specialist accommodation for older people. You set out at your 5.24, the PPG says the need is critical.
Yes.
And we looked yesterday at CD 4.2, which is the local authority's SPD, yes, which categorises the need as being acute.
Yes.
And accepts at 226 that bungalows can meet those needs. So what weight do you attach to the benefits of meeting the acute needs of older people?
Yes, again, I would say that that's a significant weight to be attributed to that provision. It's an integral part of affordable housing, open market housing, people moving, downsizing. The whole housing market almost has to work as one for it to be working as efficiently as it can be.
Next, please. Accessibility of the site is dealt with in the Statement of Common Ground at 8.2. So I want to just ask you a couple of questions about the sustainability of the settlement. Let's start, please, with, firstly, CD 5.6. At 5.10, so CD 5.6 at 5.10. What conclusion does the council's latest evidence reach as to the categorisation of Latchingdon?
Yes, the recommendation is that it moves into the category of large village from a small village.
And it's the fourth most sustainable one, and we see the reasons for that set out in the table.
Correct.
What weight do you say should be attached to this analysis as an objective piece of evidence to inform decision making?
I think background evidence. I heard what Mr. Coleman had to say, but background evidence is a material consideration. It's produced to inform not only the local plan, but it's also there to inform decisions on planning applications, because clearly the officers, when they made the recommendation, would have been aware of what the future of Latchingdon could be and the failings of the local plan. Otherwise, they wouldn't have come up with the recommendation which they came up with.
And what weight do you then attach to it?
I'd suggest has some significant weight in terms of the consideration of applications, not just this one, but any ones which are falling within sustainable locations.
And then I won't turn it up. It's CD 5.2, page 22, the issues and options document. In the light of that document, what did the council resolve to do in terms of the position of Latchingdon in the emerging hierarchy?
Well, they proposed to upgrade it to the large village.
So does the council as a whole accept the conclusions of that evidence-based assessment?
Yes, they do, yes.
Next, please, in your evidence at 550, we then have the Healer assessment. So it's your 550 on page 45. What conclusion is reached about the suitability of the site?
The suitability is that they believe the site is a deliverable site. They believe it is a sustainable site, and it has easy access or accessibility to the local facilities.
Would they?
Sorry, Mr. Cannock. Which page were you referring
Oh,
to?
sorry. It's Mr. Armstrong's 550 on page
550.
45 of the main proof.
Yep, 550. Got that. Thank you.
And sorry, we looked at this briefly yesterday. Page 46. You've got the summaries of LD4 and LD6. It was looked at 2 parcels. You've highlighted the relevant sections. Overall, both parcels were considered suitable. Would your view, because Mr. Coleman's view appeared to be, well, that doesn't necessarily mean that Latchingdon itself was considered to be a sustainable settlement. Do you agree or disagree with him on that point?
The way I read healers is that clearly, if a village was unsustainable, then that would be the findings of the healer, in essence saying this isn't a village which would then be suitable for more housing growth. It goes beyond this. It acknowledges that this is a site with access to sustainable facilities, and concludes that both elements of the site could come forward for housing in the future. I accept what Mr. Coleman says. This isn't an allocation,
No.
but it's part of the background evidence which local plan will take account of, and also the DM officers will do as well.
Next then, 4th point, the officer's report, CD 2.1. So CD 2.1.
Yes.
Page 8 of 46 at 4.1.7.
Yes.
What conclusion is reached there by the officer about the sustainability of the settlement?
Well, it concludes that it is sustainable. It starts with the smaller village allocation, then reviews the services in Latchingdon, and considers it to be a sustainable settlement for further development. So,
Sorry, that's at paragraph
4.1.7.
4.1.7. Right. Yep.
And if one then just looks at the next paragraph at 4.1.8, taking into account the observations made by the 2 inspectors in allowing appeals for residential next to the site at Beach Drive, and based on the information, the site is considered to be a sustainable location for new housing. So just pausing there, we have an up-to-date objective assessment undertaken by council officers to inform decision making.
mm-hmm.
We have technical officers undertaking the HELAR, we have the officer's report, and then we have the council accepting the conclusions of the objective assessment and resolving to upgrade, as you say, Latchingdon as a larger village. And then we have the inspector's decisions.
Yes.
So what weight do you attach to that consensus of evidence that Latchingdon is a sustainable settlement for further growth?
I think it's a significant body of evidence. It's not just one report or one note. It's actually a series of reports, and obviously those appeal decisions date from 2014-15, so they were some years ago. And even at that stage, the inspectors were happy to endorse Latchingdon as a sustainable location.
And if we just turn, please, to CD 8.4. I'm not sure I've got the right note here. Yes. So CD 8.4.
Sorry, CD
8.4. And you recall that the point was made by Mr. Coleman, well, some of those decisions were made in circumstances where there wasn't a 5-year supply, and I took him to Mr. Pycroft's evidence, which suggested that wasn't right. I just want to look at this one decision. So, decision of Inspector Board made on the 10th of September 2015. Do you have that?
I have, yes.
And so this is in respect of land to the east of Burnham Road, Latchingdon. And we see that this is the application for I think it's the 44 unit scheme, is that right?
Correct, yes.
And if you could just turn, please, to paragraph 14. What in fact was the basis of the decision in respect of whether there was a 5-year supply?
The inspector doesn't rule either way. He feels that the scheme, as he says, I found the scheme would not harm the character and appearance of the area. And then concludes in paragraph 15, it would be consistent with the framework, clearly the previous version, not conflict with the policies, but nonetheless, it would be a compatible scheme which would not harm the landscape character. So that decision was not predicated on the 5-year supply. It was predicated on a flat balance assessment of the evidence before the inspector at that time.
Next, please, economic role. We agreed significant weight with Mr. Coleman, which just leaves the environmental benefits. I'm not going back on the identity of Latchingdon point. The public open space, we know what's being provided. You've dealt with how it can be secured through the reserve matters. What weight to the benefits to existing and proposed residents of the 4.2 hectares of formal and informal public open space?
I think we're talking about a significant benefit. And that's backed up by, obviously, the green infrastructure strategy, which we went through yesterday. But there was also some comments from the parish council, which perhaps I can just refer to, in their comments to the planning application. I don't know what CD reference that is, I'm afraid, but it was a response to the outline planning application from the parish council. I don't know whether you've got that, sir. Whether I can...
I don't have it.
It's comments on the planning application. So you're talking about their consultation response? The
consultation response,
yes. I think it might be, if you want to look at the back of CD 2.1.
Thank you.
I think the consultation responses are summarised at the end of the officer report.
Yes. Well, I've got the sort of the full version, and I just wanted to point out the comments from the parish council, and I'll read them out, sir. That's probably the easiest thing to do. In terms of open space, it says it should be noted that Latchington has less recreational space than the 6-acre standard, and whilst this is an increase in space, it will not reduce the overall deficiency because it's separate and segregated. So basically they're saying it's too far away to actually have any benefit. Well, that's obviously a decision for you to decide, so whether it is or whether it isn't. But nonetheless, they've accepted that there's a shortage of recreational space in Latchington at the moment. And the second comment to policy E3 is it should be noted that Latchington has extremely limited and old children's play facilities. There is also an absence of any youth amenity or infrastructure, and this is a major area of concern. So there, I appreciate I'm not trying to suggest the parish are supporting the scheme in any way, but they've honestly made it clear that the open space, which was discussed as part of the pre-application discussion, will actually meet an identified need in the area. So that's a need identified by both the parish and the authors of the green infrastructure note as well.
I'm not sure that's captured in the summary.
No, it's not, sir.
It's not.
I mean, as you say, as you fairly point out, Mr. Armstrong, they obviously object to the proposal. But yeah, I think the summary in the officer report doesn't actually pick that up. So I mean, it might be useful to have have that uploaded as a either an inquiry document or a core document, if it's not already.
No, I don't think it is.
No,
so we can do
it might be useful to have that provided, given that you've referred to it, Mr. Armstrong.
Yeah, I'll leave it out for copying, sir.
Okay, so significant weight to the public open space, and then biodiversity net gain, if you look at the statement of common ground at 816, don't need to turn it up, it's a matter of common ground that it would result in a significant net gain in biodiversity. Is that correct?
That's correct, yes.
Okay.
And which we've given moderate weight to that benefit.
Moderate weight.
Moderate weight, yes.
And so just drawing the threads together then, so you've identified the conflict with the development plan, you've identified the material considerations. Why do you say in this case the material considerations should outweigh the conflict with the development plan?
For two reasons. I think one is clearly the failure of the plan to deliver where it should be at this particular stage of its life. The unquestionable need for market housing as a result of that, and affordable housing as well. And then the benefits which the scheme is offering over and above the sort of benefits which you would normally expect to see developed with a scheme. So the increase in the affordable, the increase in the biodiversity, the 3 times amount of open space that we would normally provide, which is clearly meeting an identified need. So there are significant material considerations to take on board when compared with the breaches of the policies which we've been through at length, which, for want of a better phrase, I classify as technical rather than substantive. That's for discussion. And I think on that basis, I think the pendulum swings in favour, and that's exactly what the officers did when they wrote their committee report. I mean, I think the fact that that officers' report was written positively is something I haven't come across for a long time.
And just to be clear on that, I'll lead on some of these points, but it was written positively in the context of a higher housing land supply than we've agreed,
Yes.
a lower level of affordable housing and a lower level of bungalow provision.
That's correct.
So, well, we'll leave it there. The inspector can make of that what he wants.
But in light of the issues for an officer or officers to write such a positive, flat, balanced application in these times, for want of a better phrase, the officers were clearly of a view that this site and sites like it should come forward. And they stood up and defended their position in this room with members who unanimously did not like what was presented to them, which is why we're here today. But officers defended their position as best they could and presented the case as best they could. And I think that is a fairly unique position, which I think reflects the position the council find themselves in.
Thank you, sir. Those are my questions. Thank you, Mr. Armstrong.
Thank you very much, Mr. Cannock. We could take a short break now before you start your cross-examination, Mr. Wilcox. Roughly how long do you think you might be?
I think I will be around about an hour and a half, maybe.
Right, okay. Well, let's just have a short break now, and we'll come back at, it's now nearly 2:20, so if we come back at 3:25, if that's okay. Yeah, thank you.
Transition, and you are now on the live stream.
Right, well, good afternoon, everybody. We'll resume the public inquiry. We're now at the stage where the appellant's witness will be cross-examined by Mr. Wilcox of the council. So I'll allow Mr. Wilcox to start his questioning.
Thank you very much, sir, and good afternoon, Mr. Armstrong.
Afternoon.
I'd like to begin, please, with the really, really big picture point about the balancing exercise which the inspector is required to undertake here. As we all know, Section 38(6) is the legislative framework. Starting point is the development plan. Where there's compliance, you usually follow. Where there's non-compliance, you follow to way of a refusal unless material considerations indicate otherwise. So far, so good?
So good, yes.
There's nothing flat, is there, about the Section 38(6) balance. It is tilted firmly in favour of the answer given by the development plan.
Yes, your starting point is the development plan.
That's right, and that's recognised in the NPPF as well, paragraph 12.
Yes, correct.
And it's a particularly powerful presumption, isn't it? Because it doesn't flow from policy, but from law. It's a statutory presumption.
That's correct.
Thank you. And you confirmed in chief very helpfully that you accept conflict with the development plan overall in this case.
I do, as I explained,
As you-
how I see that,
As
yes.
you explain. You also accept, and this is in your proof, it's a basic point, so I don't think we need to turn it up. You accept that the NPPF tilted balance, the paragraph 11 tilted balance, is not engaged here.
That's correct.
That's correct. As we know, there are three ways in which the tilted balance can be engaged. The most important policies can be out of date, or you can not have a 5-year land supply, or your housing delivery test score can be below 75%, in essence, for this sort of proposal.
Correct, yes.
You accept tilted balance isn't engaged, which means you accept that none of those three triggers apply.
That's correct.
Thank you. Let's have a look at the development plan itself, please, core document 3.1. Now, you make a point in your proof, which is that your assessment of S1 non-compliance effectively flows from your conclusions on S2 and S8. So what we'll do is we'll come to S1 last,
Okay.
I think. Let's start, please, page 17, policy S2, which is our strategic growth policy, as we know. That policy establishes and gives effect to the housing allocations, neighbourhood plan allocations and windfall allowances, effectively as the sources of future delivery, doesn't it?
That's correct, yes.
It directs development to those places which was judged by the democratically elected councillors of the district to be most appropriate at the time that it was approved.
It does
Yes.
indeed, yes.
That's right. And it's common ground, isn't it? The site isn't within any of those identified sources.
That's correct.
Hence our conflict with S2, which you accept.
Correct.
Policy S8 next, please, which is page 45. Now, we haven't dwelt yet on the supporting text which precedes the policy. It's worth just having a little look at 2.100 and 2.101. What these do, Mr. Armstrong, is they establish broadly two functions for policy S8, don't they? Function one is it helps to inform neighbourhood planning and development control decisions, which is what 2.100 tells us.
It does, yes.
And number two is it provides further clarification, as it puts it, in terms of the types of development that may be more suitably located in the countryside with reference to other LDP policies. So that's its second function. Do you see that as well?
Yes, I do, yes.
And it's in that context that we need to have a look at what the policy says about development in the countryside. That we know it tells us the countryside will be protected for its landscape, natural resources, ecological value, and its intrinsic character and beauty. And it then sets out the two-part test for development beyond settlement boundaries, doesn't it? One, intrinsic character and beauty of the countryside not adversely impacted.
Yes.
And two, there's then the list of development types which are acceptable.
Yes.
Yeah? It's a long list, isn't it?
It certainly is.
The long list of things which are acceptable beyond boundaries. That includes residential development, doesn't it? You can see Limb G, agricultural and essential workers accommodation.
Yeah, I mean,
Yep.
that would produce a very limited number of dwellings, but yes, and
Yep.
I would expect to see that there in any event.
Yep. Similarly, we'd expect to see royal exception sites, and we find them at H.
Yes.
Yep. And it's worth noting M as well, other proposals in compliance with LDP policies, neighbourhood plans and other local planning guidance. And that could, at least theoretically, include housing, couldn't it? If it was allocated by a neighbourhood plan.
Well, you would then have to go back to policy S1 and S2, wouldn't you? Which
Which we're going to do.
we're
don't we?
going to, which
Yep.
and the absolute reading of these policies is that you wouldn't get past S1 and S2 unless you were unless you're an allocated site, Win4 site or a neighbourhood plan site.
And of course, a neighbourhood plan site would be entirely consistent with M, wouldn't it? Because
could
it
be,
reflects
yes, it could be.
neighbourhood plan allocations. Yeah.
Yes.
Now, you've described the effect of this countryside policy in various ways in your proof, and we have noteworthy expressions like a ring of steel around developments and no flexibility for change, very limited, if any, development outside of the boundaries. Those expressions you, I'm sure, recall. Yeah.
Yes, absolutely.
But of course, as we've seen from the long list of development types which are acceptable, there's no ring of steel or anything like that here at all, is there, Mr. Armstrong? What's happened is that the proposal, the policy, forgive me, sets up a significant number of types of development which are acceptable. The problem is that your client's type of development isn't on the list. That's not the same thing as a ring of steel at all, is it?
No, I think it is a ring of steel. Whether my view of it would be the same whether we've got a scheme or not. It limits the opportunities for sites which don't fall within the categories to come forward, and that clearly includes housing. Most of those criteria there are long-standing uses appropriate for use in the open countryside. So there's nothing. It's not introducing anything new or whizzy. All those things have been around for some time. So it's not offering that opportunity for a balanced review of whether or not a housing site, for example, can be considered suitable based on the material considerations and the benefits flowing from it, which clearly is what the MPPF is now suggesting we do.
Well, we're going to revisit that point when we look at S1, if that's okay. Sure. But for now, on the idea of the restrictiveness of the policy, it's a point you made in chief, and which you also make in your proof, is your suggestion that the restrictive nature of the policy is such that it's inconsistent with para 180B of the MPPF, which has shifted.
Yes.
The old PPS 7 language of protect the countryside to the new language of recognise intrinsic character and beauty.
That's correct, yes.
I'd like to have a look with you, please, at what the examining inspector said about that in the course of examining this local plan. And for that, can we please take up court document 3.16?
Yep.
And we're going to go to PDF and hard copy page 23, please. Sorry, we'll go one above. We'll go to 22 initially.
22, yep.
And we'll see there's a heading issue 2. Do you have that?
Got that.
And issue 2 about settlement hierarchy. We can see from the very first words of paragraph 115 that this is all about policy S8. The inspector goes on to describe what the policy is doing, reaching the point in 118 of noting that the policy sets out a coherent hierarchy of settlements. Do you see that?
I do.
Yeah. Then discussion about attempts to move placing of settlements within the hierarchy one way or another, some seeking alterations to settlement boundaries, all the kind of things that we know go on all the time in examinations in public. Yep. Some suggestions, the inspector, I should say for clarity, rejected all of those at the end of the paragraph. 120, some suggestions about correcting errors, which is quite a discrete point. And then at 121, we get this about S8. This is not, as some appear to suggest, a blanket ban on rural development. It describes new windfall housing is permitted within the settlement boundaries. List of development types allowed outside the boundaries is not overly stringent. It describes all the things it does. All of the uses supported outside the settlement boundaries are, in my view, appropriate and consistent with paragraph 28 of the framework. And then we get an important sentence here. Indeed, I consider the approach taken by policy S8 to be consistent with the framework's core planning principles. It strikes a suitable balance between recognising the intrinsic character and beauty of the countryside and supporting the thriving rural communities within it. Do you see that?
Yes.
So the examining inspector, when he was considering the compliance of S8 with the MPPF, was very much not applying the old PPS 7 approach, was he? He was applying the MPPF approach as it was in 2012 and as it is now. Recognition, not protection. Do you see?
Yes, I see that.
And the inspector's conclusion in respect of whether S8 was consistent with the framework's recognition of intrinsic character and beauty was that it was, wasn't it?
Yes, I'm just... the way I read that is clearly the inspector was being presented with a certain strategy by the local authority, which was very specific about how to deliver their housing requirements. There was no leeway other than the way that the local plan sets it out. So in which case, the inspector was then asked to basically draw a ring of steel around the various policies to ensure that those policies are delivered. So what he's saying is what's being presented to me, which is S8, I'm happy with, because those uses named within it are the sort of uses you would normally accept in the open countryside, so he's got no problem with those uses. And he's considering those uses as being the ones which then strike a suitable balance between the intrinsic character. But clearly at the beginning, he's been told that new windfall market housing is permitted only within settlement boundaries. So he's been told that the council are not going to look for market housing in the open countryside as part of their strategy.
He's been told that, and he's regarded that as acceptable and consistent with the framework.
On the basis of the strategy being presented to him by the local authority, for them to be able to focus the development in the three key towns. What they want is for developers to focus there rather than necessarily in greenfield sites. And so I understand why they're doing it, and he's gone along with their case. Clearly, what we're looking at now is a situation which hasn't arrived. If the inspector hadn't liked their case, he may well have said that he wanted more flexibility for sites in greenfield locations to come forward, but he didn't, because that wasn't what was presented to him.
But the difficulty with all of that, Mr. Armstrong, is that your fundamental criticism of S8 is that it seeks to protect rather than to recognise intrinsic character and beauty. And that's true whatever your strategy is, isn't it? That's a point about the structure of S8 itself, about its absence of, as you put it, inbuilt flexibility.
Yeah, that's true. But
And the inspector didn't
Sorry, that's true. Sorry to interrupt. But I think in this instance, there was a very specific strategy which was being presented to the inspector. Had the inspector been worried about the council delivering, the inspector may well have looked at having a more flexible approach to sites in the open countryside on the way that the MPPF sets it out at the moment. So inspectors are there to help and support local authorities deliver their local plans, to respond to their strategies. They're not there to make the strategies up there saying, is it sound? Is it moving in the right direction? How do I need to set those policies up to make those strategies work?
Yes,
and that's what he's responding to here.
That's what he's responding to, and a part of his job in doing that response is to test what's being proposed against consistency with the framework. He tested S8 as structured against the framework, and he found it to be acceptable.
As presented to him as part of this appeal.
The
inspector didn't have carte blanche to say, actually, I think the wording of S8 should be made wider, because that's what the MPPF says it should be. He is looking at the strategy in front of him at that particular moment.
final point for the sake of completeness on all of this is paragraph 124, conclusion on issue 2, considering the above with the main modification put forward by the council and as discussed, and that was adding in the wording to 2.100, which we saw. I conclude the settlement hierarchy and the plan's approach to settlement boundaries and the countryside are justified, effective, consistent with national policy and positively prepared. Do you see that?
I do see. Yes.
Yeah, thank you. Now, having done that, I hope fairly brief and painless canter through those two policies, we can now return to S1, please, which we find at page 15. Just going to find my own, and there we go. So forgive me, it's page 14 electronically, isn't it? There we go. So page 14, we know, don't we, this is the overarching sustainability policy for the whole plan. So do you have it?
I can't count them on. I thought it was. Is it 40?
I've got 14, yeah.
1-4.
1-4, the PDF.
I've got a hard copy here, so don't worry. That's fine.
But yeah, if you use, it's page 14 in the hard copy as well, happily.
S1, yes, got S1.
S1, you have it. So this is the sort of overarching sustainable development policy of the kind we're all familiar with, yeah? And we know, it's important, I think, just to dwell for a moment on the whole structure of the policy. We know that it suggests a positive approach towards development, reflecting the presumption in favour of sustainable development in the NPPF. It sets up the key principles in policy and decision making. We've got 2, 3 and 12, which we'll return to in a moment. But in terms of the overarching structure, we need to carry on to the next page, don't we? Where we find this within the policy box, that planning applications that accord with the policies in the LDP and where relevant, neighbourhood plans will be approved unless material considerations indicate otherwise. Do you see that?
I do.
So that's reflecting what we would now call NPPF 11C.
Yes.
And then we have this, where there are no policies relevant to the application or relevant policies are out of date at the time of making the decision, the council will grant permission unless material considerations indicate otherwise. Do you see that?
I do.
So this is effectively bringing the NPPF tilted balance and its triggers into the development plan itself.
Yes.
You see that?
I do.
And that's important, isn't it, for assessing the flexibility of the plan as a whole. Because what it means is this: when you suggest that there are severe or ring of steel type restrictions within S8, the development plan itself only applies those restrictions where you have a 5-year housing land supply and where your housing delivery test results are above 75%, doesn't it?
Yes.
In the event that you have a failure of supply in falling below 5 years, or you have a failure of delivery in it falling below 75%, then this final paragraph of S1 effectively switches off S8, doesn't it?
It reduces the weight of S8.
Yeah,
It doesn't switch it off, but it reduces.
no, but the development plan contains a policy which tells you
Yes.
what to do
Yes.
in that situation. So
And clearly there were a lot of greenfield sites were approved through that mechanism when the tilted balance was in play for the applications we talked about earlier.
that's
So-
right. So there's your flexibility,
Yeah, no, I
Mr.
understand
Armstrong.
that. Yes, I understand
There's your
that.
flexibility. You have flexibility when the NPPF's mechanisms for identifying housing delivery or supply problems would bring the tilted balance into play. And it's common ground between us, isn't it, that the NPPF mechanisms aren't in play in this case.
That's correct.
So the reason that S8 applies in the protective way that it does is because on NPPF terms, there isn't a problem in this district with supply or delivery of housing.
Well, that's perhaps where we might disagree.
Well, let's think about what the NPPF tells us there. I mean, the NPPF gives us a whole series of mechanisms, doesn't it, with a whole series of consequences. Beginning on the supply side, We can turn it up if we need to, but this I'm sure would be bread and butter to both of us. On the supply side, we have your 5 years supply position.
Yes.
If you have more than 5 years, tilted balance isn't engaged.
Yeah.
If you have less, the tilted balance is engaged. So that's a supply side mechanism for tweaking weight.
Yes.
Yeah.
Yes.
On the delivery side, we have paragraph 79,
Yes.
which again we can turn up if need be. I'm
Yeah,
sure
no,
you
I'm
know
happy,
it.
I'm happy with that. I think the difference here is clearly the flat balance argument, which we're talking about today, and clearly the officers grappled with when they prepared their committee reports. This doesn't consider the flat balance being an option moving forward. It allows development to come forward under the circumstances you've explained, and I agree with you on that. They are the obvious reasons for sites, for applications to come forward, but they're not the only ones. The flat balance is always there, material considerations are always available, and the background evidence and the weighting of those material considerations should then be weighed in favour of a scheme coming forward on that basis, which is exactly what professional planning officers did when they made the committee report.
But of course, they're more than, I think you used the term obvious reasons why it'd be triggered. The 5 year supply and 75% HDT mechanisms, they're not obvious. They're the ones that the central government has told us to look at in terms of how this all works, aren't they?
Yeah, okay. Obvious is perhaps the wrong word, but they are the sort of the standard approaches.
Yeah, they're the ones
which
mandated by national policy.
Yes, I accept that. And I accept that the policies as worded, given the significant number of greenfield sites which have been approved through that mechanism, I understand that officers and members have dealt with that through that particular process. We're going through a different process here, and that's where the wording of these policies becomes somewhat difficult and troublesome when you're trying to do that balancing exercise.
Well, you say troublesome, Mr. Armstrong. I'm going to press you a little on that. There's nothing troublesome, is there, about policies seeking to direct development in particular directions, the directions democratically approved by the elected members, in circumstances where both supply and delivery are healthy in NPPF terms?
Yes, if the plan is delivering as per the policies.
Which we measure by reference to the HDT and the land.
So that's one. There are ways of measuring it. There are other ways of measuring it as well. I mean, there are, as we've discussed today, internal reviews done by the local authority themselves, which criticise the plan not being fit for purpose. The evidence base shows that the delivery of where we should be today hasn't been achieved, so therefore it's not fit for purpose on that front. So the plan shouldn't be stuck. Repeat when the outcomes of those policies are in themselves not delivering.
And again, I'll don't want to labour the point with you, but the point between us is in what not delivering means in this context, isn't it? Because if you measure whether it's delivering or not by reference to whether it is meeting or failing the NPPF tests for delivery, then this plan is doing fine. It's got almost 6 years land supply and 155% HDT score.
Against those tests, we're not challenging on that.
No.
It's the other areas where we are at odds with you. The difference between myself and Mr. Coleman is that Mr. Coleman is keeping his fingers crossed that the permitted consents which are out there will suddenly start to deliver and get the council out of a hole.
Well,
we don't think that is the case.
I understand that's the point between you. We'll return to that a little bit later on. Within S1, I promised I'd come back to the list of key principles, and now's the moment when we're going to do so. You accept, don't you, that the proposal breaches key principle 2. It's not a sustainable level of housing growth that will meet local needs and deliver a wide choice of high quality homes in the most sustainable locations because of the S2 breach.
Yes,
I appreciate you described that as technical, but
yes,
it's a conflict, isn't it?
It's a conflict on the use of the word most sustainable locations, which are defined as your 3 main towns.
Yeah, that's right. Number 3, similar point. Effective use of land and prioritised developments on PDL and planned growth in gardens, so that's strategic allocations. Again, because of the result of the S2 question, we have a breach here as well.
Correct.
Yep. And on point 12, rural character of the district without compromising the identity of its individual settlements. Can I take it that if the inspector is against Mr. Milcreast and his evidence, he's also going to be against you in your evidence on this point? I don't need to repeat my questions.
No,
to Mr. Milcreast,
I think both of us see the issues in very similar ways. Yes.
Yeah, that's what I hoped you were going to say. There is one point, however, which needs to be picked up with you, I think, on this question, which emerged from Mr. Milcreast's re-examination, which of course I don't have a reply to. You'll recall we were looking at the characterisation assessment with Mr. Milcreast.
Yes.
And you'll recall he was asked some questions about which was worse out of a nucleated development form or expanding the ribbon, as it were. He identified what he thought would be more severe landscape and visual implications from lengthening ribbon development.
Yes.
Do you remember that?
Yes.
And you'll also remember the questions I put to him about the problems with nucleated development, which that document identifies. Yeah. So you're effectively stuck between the devil and the deep blue sea with this, aren't you? Where you expand them in a nucleated way, you lose the linear character, and you expand them in a ribbon fashion, and you're going to create a adverse landscape and visual impact. You see that point?
Yes.
Yeah. That is a very, very good reason indeed, isn't it, to impose strict controls on development beyond settlement boundaries for this kind of settlement, because however you develop them, you're going to cause a problem, aren't you? You're either going to impact on the agricultural character of the settlements, or you're going to create an LVIA issue from lengthening the ribbon along the road.
There'll be change, and the key to it is the extent of that change and the specifics of the village in question. I think, as Mr. Moncrief was explaining, is that Latchingdon, being one of the larger villages, not as defined yet, but being one of the larger villages, had a smaller linear core, and from the 60s onwards was already expanding outwards. It's okay. So in terms of deciding whether or not preservation needed to take place, it wasn't the type of village, for example, some of the smaller villages where development has effectively stood still for many, many years. The linear pattern is still very obvious to everybody, and any development which had to come along, clearly the starting point would be it should be in parity with the area. You may obviously find these villages are in conservation areas as well, and there are village plans or whatever it is to protect these particular characters. No such preservation or character exists in Latchingdon. And what we've seen over time is that Latchingdon has consistently expanded away from the linear pattern. There's 162 houses have been built in Latchingdon. Majority of those are not in the linear form. So the character of the area is already mixed, for want of a better phrase. There is no strong linear pattern. What remains of it is obviously the road pattern and the network and those properties which do front onto those roads. But you've now got a significant increase, which is more nuclear in pattern, and actually sits very well with the older part of Latchingdon. And they were obviously approved at local level and approved at appeal, and the issue of linear development has never come up in any of the decisions or the issues which I can see from other schemes.
Well, as the inspector's heard my questions to Mr. Milcreast, has heard your answer. I'm not going to go over all of that with you again. As you well know, we on this side of the table don't accept that analysis, but we're not going to go through it all again.
That's fine.
So we've got conflicts with key principle 2, 3 and 12. You accept, don't you, that's sufficient to create a conflict with S1 overall?
I do, yes, accepted that.
Thank you. And S1, S2 and S8 combined are weighty enough to result in development plan conflict overall, which we've established at the outset. Thank you. I'm glad to say we're making much better progress than I thought we would, sir, so we may be finished even sooner than I'd anticipated, which I'm sure we'll all be grateful for, won't we? Turning then to some material considerations points with you, Mr. Armstrong. You'll be glad to know I'm not going to go through each and every difference in weighting between you and Mr. Coleman. I don't think the inspector would thank me for it, and I don't think he'd be helped by it.
Nope.
So what I'm going to do is I am going to focus just on a few of them where there are key points of difference. And I'd like to begin, please, with the market housing position. Now, we all agree 5 years isn't a cap in supply terms. And I'm not going to suggest to you for a moment that housing doesn't carry weight if you have more than 5 years supply. You know, that would not be something I would advance. It's not something that anyone can sustain. But it's inevitably the case, isn't it, that the weight to be attached to market housing provision will go down where the supply position goes up. Better the supply, less weight to new houses.
Yes, as a general theme.
As a general
I would
proposition.
agree with you on that, yes.
Yeah. Okay. And we've already had a bit of a think about how the MPPF measures these questions, haven't we?
Yes.
The MPPF is, as we all know, the central government's mandated approach to how we deal with questions both of plan making and decision taking. Very powerful material consideration, as we all know.
Yes.
And the tests which it establishes are the tilted balance for supply,
Yes.
and a tiered series of more and more severe consequences for an authority, depending on the level to which it fails its HDT.
Yes. Yep.
Yeah.
Yes.
So if your HDT is 95%, you need an action plan. If it drops to 85%, you need an action plan plus a 20% buffer on your land supply. 75%, it's those two things, plus you're within the tilted balance.
Yes.
Yeah.
Yes.
So, and that is a graded test that's being considered by national policy, isn't it?
Correct.
And the yardstick which it uses to measure suitability of delivery rates and to apply that graded sequence of ramifications is the HDT, which is, broadly speaking, your delivery rates over the previous 3 years. You're aware of that?
Yes. Yes.
Yeah.
I'm aware of that. Yes.
Yeah. Now, that being so, it's important, isn't it, in this case to look at the agreed numbers. You know, it is common ground here that our HDT score is 155%, isn't it?
It is. Yes. Correct.
In other words, over the last 3 years, over the period the MPPF tells us to think about, there's an over-delivery of housing in this borough.
Under the HDT, yes.
Under the HDT, which
Correct.
is what central government has said to look at.
Yes, it's a tool to be used for that purpose. Yes, correct.
Yeah, in fact, it's the tool to be used for that purpose in the MPPF, isn't it?
In terms of the MPPF, it's sub 5 years and HDT are the tools to.
They
use
are the
those.
tools. Yeah.
Not exclusive, but they are the tools which your starting point is.
Yeah,
Correct.
and as we've said on housing land supply, we're at 5.97, so
Yeah.
not even marginal, well above the point at which the tilted balance fires, isn't it? What that means, therefore, Mr. Armstrong, is that on the detailed, structured, gradated approach of the MPPF, there's no need, is there, to disturb the development plan position in Malden as a result of market housing need?
That's correct. If you stop at that particular point, clearly
Yeah.
we've gone beyond that and we've looked to see what sits behind the council's delivery of their housing numbers through their local plan, and I think that we see a problem which is not part of the MPPF tools, but is a matter which we believe is significant for the flat balance consideration for this particular scheme.
Now, you say flat balance. I think we agreed earlier. We're in a section 38.6 tilted balance, aren't we, as it were? Where by flat you mean MPPF tilted balance not engaged.
Correct. Yes.
Yeah.
Yes.
Okay. You
Yeah,
accept, don't you, that there's a presumption in favour of refusal in this case
No,
because of the development plan conflict.
I'm not going over that.
No, that's fine. I just wanted to make sure we were all clear.
Yeah, no. It's the materials considerations and circumstances, which is the area which we're looking at.
That's great. Just a very, very little bit. You'll be glad to know I'm not going to get into a lot of numbers with you, but I do want to take a brief look, please, at the most recent AMR for the district, which is called document 3.3, please. Just find it myself. There we go. And this, I'm sure, is a document that you're familiar with yourself.
Yes, we went through it with
This
Mr.
has
Coleman.
been seen with Mr. Coleman, yeah, and we note, don't we, in table 1 that the shortfall for each year is shown there. We're at a total sort of net shortfall, as it were, across the plan period of 109 dwellings.
Correct. That's agreed.
Yeah, and then table 2 shows us the position on the allocations. Do you have table 2?
I have, yes.
Great. And Mr. Coleman was right, wasn't he, to point out that as things stand at the AMR base date, there is plenty of headroom for future delivery in these allocations, isn't there? If we look, for instance, at S2D, that's got 1,138 capacity within the planning permission, which hasn't started delivering yet at all. So all of that delivery is going to be future loaded, isn't it?
I agree there's headroom. What worries me more is that the 480 of those should have been delivered by 22, 23, and they haven't. Nothing's been delivered. And I think that's the substantial issue between us is the optimism, which Mr. Coleman is looking at that table. I'm looking at it in a more realistic fashion, thinking there's only 38% of the sites delivered
We look.
to date.
Sorry, that's fine. I didn't want to cut across you. I thought you were finished. If we look at S2A, for instance, which is, I think, another one of the other end of the garden suburbs, isn't it? I can't remember if it's the north or the south one, but that's on that one we could see we've got a net permission of 1,000, and that one actually is delivering, isn't it? We can see that one's delivering.
Some of them are delivering, and some of them are not delivering. Some of them have got zeros. Three have got zeros against them, and that's worrying to my mind that those sites haven't even started to deliver.
Thank you. One moment, please. Yes, that's right. Now, you've dwelt in your evidence, and Mr. Cannott dwelt with Mr. Coleman in his examination on the inclusion of greenfield sites within the supply position so far, and on the can't think exactly the words you used for it, but it was along the lines that this district has used greenfield sites to get to the supply position that it's in. Now, we've got to be wary here, haven't we, of a logical non sequitur. Even if there were a case for allowing greenfield development in this district to achieve an ongoing healthy supply position, which we don't accept, but even if that were the case, it doesn't follow, does it, that this greenfield site should be delivered. We have to be careful there, don't we?
No, I fully accept it doesn't automatically follow just because there is a history of. You have to look at the site as a suitable housing site, as well as
absolutely
the overall issue. So no, I fully accept that.
Good, thank you. And of course, I hope you'd also accept that if the inspector agrees with Mr. Coleman and not Mr. Milcreast on impact on settlement identity and rural character and things like that, and finds that this scheme would have an adverse impact, such as to engage S112, that would be a perfectly good reason, wouldn't it, for not choosing this greenfield site?
It would be a matter for the inspector to add to the planning balance. And the conclusion would then flow from the exercise the inspector would then have to do.
Thank you very much. And then we're actually almost there, you'll be glad to know, Mr. Armstrong. We've made much better progress than I thought we would. Or my estimate was wildly off, which I think is probably more realistic.
You're never criticised for that.
No, that's right.
Indeed, Mr. Wilcox, it's much appreciated your speedy approach.
Well, so we're at the point where, as is often the case with the very final witness for the final main party, everyone knows what the issues are.
Indeed,
you won't be assisted by me banging away.
Indeed. Well, thank you anyway for everyone's cooperation. Thank you.
Absolutely, and with that in mind, I'll move to my very final topic, which is environmental benefits. I just wanted, I was a little bit confused by the approach in your proof, but I think I understand it better from Chief. So I'd just like to test this now. It says, paragraph 5.86, you identify moderate weight to all positive factors that point to the environmental sustainability of the scheme and weigh in its favour. I think based on your evidence in Chief, the moderate weight you assign to the BNG delivery, and you assign significant weight to things like the open space delivery. Is that right?
That's correct.
I thought that was the position. I just wanted to check I'd understood. On the latter of those two, then I'm not going to ask you anything about BNG.
Just everyone knows what we're talking about. We're talking about biodiversity net gain. Is that?
That's the one. So
I'm just aware. No. I know we often end up talking our own language, and a lot of people, who might be listening might think, what are all these various terms that we're using? But just to be clear, yeah.
That's right. But there's a requirement within various national policies for there to be a biodiversity net gain, so for the sites to make things better in biodiversity terms. The number which we often use to assess that is whether it's more than 10%. And in this case, this is more than 10% by quite a way. So that's why there's no dispute about that. On the attachment of significant weight to the green space type of environmental benefit, you've described in your proof, haven't you, the various benefits that flow from the provision of that green space within your section on community health, social and cultural well-being.
Yes.
But that benefit is tempered, isn't it, by the harm to the intrinsic character and beauty of the countryside that is going to emerge from building on what is at present an undeveloped green space. It's a good thing to have this publicly accessible green space and so on, but it's also a bad thing to be building on fields in the first place in environmental terms.
I understand, but I think it's two separate exercises. You look at the scheme as a whole, which includes the open space in terms of its impact, which I think we've agreed it's got limited impact in terms of landscape harm, and we've had the discussion on the category 12 point. So I think you look at the scheme as a whole to start with, and you do the assessment then, and then you go beyond that to say, if that harm is deemed acceptable, which we say it is, it's fairly limited, then you look at say, well, what are the benefits then flowing from the scheme itself? And we say the open space has significant benefit.
One moment, Mr. Armstrong. Yeah, I'm not going to do that. Lovely, Mr. Armstrong, thank you very much. So those are my questions.
Thank you, Mr. Wilcox, for that. That's most helpful. Thank you, Mr. Armstrong. I don't have any specific points that I want to put to you. I think Mr. Wilcox has asked most of the questions that I was going to put, and I think we've had clarification in your examination in chief regarding the issue of securing any landscaping belt via the framework plan. I think I'm not sure if the conditions are currently framed in that way or not, but you seem to be happy that could be an approach that is adopted.
We're happy. They're not framed that way at the moment, sir, but we're more than happy for a condition to require the framework plan to be the sort of starting point for any future reserve matters.
Yes, I mean, I don't know whether I'm just looking at the list. We don't have, as far as I can see, a condition that with plan numbers on it, do we? Or do we? As I say, I've only looked at this in a very cursory way, because I would have thought we would need one anyway to identify the site.
Yes.
So that's something that we could address.
Yeah, I mean, as I say, I was only supplied with these earlier today, so I haven't really had a chance to go through them in detail. But I mean, even even in the most basic outline scheme, you would normally have a condition saying, the identifying the site. That would what you would normally do, I think.
Perhaps the thing to do, sir, is to pick all this up in the round table.
Yeah,
and resolve it.
I think so.
I'd like to be able to speak to.
Indeed, and
clients.
it also will allow, if I can have the opportunity, obviously, to look through these in more detail, that would be good. As I say, I've only looked at them in a very cursory way so far. So, but I appreciate your acknowledgement, Mr. Armstrong, that you're happy in principle for that to occur. And I should just make it clear to everyone, this is in the event I was minded to allow the appeal. The conditions discussion is always part of the process that we go through with these kind of events. It doesn't mean that I've made my mind up. So thank you for that, Mr. Armstrong. Mr. Cannock, do you have any?
Yes, sir. Just a few points. Sorry to prolong matters. Can we start, please, with? Do you recall you were asked about policy S8 and the inspector's report at 121?
Yes.
So CD 316 at paragraph 121. And Mr. Wilcox's questions were around, and I'm just going to take you to the last line. Policy S8 strikes a suitable balance between recognising the intrinsic character and beauty of the countryside and supporting the thriving rural communities within it.
Yes.
And your view, please, on whether that was a reasonable conclusion to reach in 2017, when the case that was being put is that we can meet market and affordable housing provision within allocations at the three main locations. Your view on the appropriateness of the conclusion at that time?
Yeah. No, as I said, I think that was the inspector's response to what he was being presented with, and I understand why the inspector has gone down that particular route.
If we look at paragraph S8 as things stand today, please. So CD 3.1. Page 49 of the PDF.
S8, yep.
Well, actually, as I interpret and apply the policy, what balance, if any, does it allow me to strike?
It doesn't allow any balance at all. That was the point I was making. It protects, and it protects the landscape and the intrinsic character and the beauty of the countryside. And it would be almost, unless you were one of those criteria, it would be impossible to get past the wording of S8.
And the inspector concluded balancing, recognising. Well, actually, does the policy apply a test of recognising?
No, it doesn't. No.
And your view, please, on whether recognising is the same as not adversely impacted upon?
No, it's different. It's a different test altogether.
Right. So in circumstances where the plan is not meeting needs, your view, please, on whether that policy, as interpreted and applied objectively, is consistent with the approach of the framework?
No, it's inconsistent with the wording of the framework. It doesn't allow any balancing, any considerations of what a flat balance proposal might actually deliver to the council.
And so in terms of a proposal for a mix of 50-50 market housing assisting in delivering affordable housing, so schemes such as this, which is more restrictive, policy S8 or national greenbelt policy?
Policy S8.
My learned friend then was taking you to policy S1, and the point that he was making is there is an element of flexibility in the plan in two regards, I think. Firstly, there are exceptions in policy S8. And secondly, there is this, I won't put it as elegantly as he did, but effectively importing the tilted balance into S1. Okay. I want to ask you, in terms of the flexibility of that tilted balance, which he said would be engaged where there was not a 5-year supply or an HDT of 75%, do you recall?
Yes.
What flexibility is there in circumstances where you perhaps have a 5-year supply and an HDT over 75%, but an acute need for affordable housing? What flexibility is there?
Well, there isn't any as set out in S1.
An acute need for specialist accommodation for older people. What flexibility is there?
Again, there is not.
Where there's a failure against the annualised housing requirement in the plan, what flexibility is there?
There is none. You've got to look beyond what the policies are saying, which is why I was coming back to the officers' report to committee, who did exactly that. They took this as their starting point and then looked beyond what the policies say, and they looked to see what the development plan was trying to achieve.
Okay. So the point then is just though about the 5-year supply. Could you just turn to perhaps the NPPF, possibly slightly trite, but NPPF paragraph 60. Paragraph 60. Of the NPPF, sir. And Learned Friend was asking questions about, perhaps this is the difference between us because it depends on effectively your trigger when you're meeting the 5-year supply in the HDT. If one looks at paragraph 60, oh, apologies.
60, we're talking.
60, sir.
Yeah.
What has been and remains the government's objective in terms of housing land supply?
To boost the supply of housing supply. Yes.
Right. And then if I look at paragraph 61, what we have to recall, of course, is that the 5-year supply is against a figure which is lower than the minimum requirement in the development plan to meet the minimum economic requirement.
Correct.
Right. And so paragraph 61 is talking about a minimum. Your view, please, on whether meeting the minimum against such a housing requirement or 75% of the HDT, how does that relate to supporting the government's objective to significantly boost the supply of homes?
Yes, as we've said in the evidence, it's the objective 310, as set in the development plan, should be the minimum number moving forward to deliver the objectives of the plan.
And then just a final point, I think, just about CD 3.3. CD 3.3. And we see this table 2. It's in the technical note in a slightly different form in Mr. Pycroft's evidence.
Table 2.
Table 2.
Yep.
And it's effectively a stock of permissions point.
Yep.
Just want to understand this, please.
So just so I'm clear, Mr. Cannock, we're on the strategic housing land. Are we on
CD 3.3?
That's the AMR, sir.
The AMR.
Right. Yeah, the AMR. Okay, and we're at paragraph.
So it's table 2, sir, on
Table
page 2.
Okay. Yeah. Okay.
And
we were looking at this.
yes, just a moment ago.
Yeah. Yeah.
So what we have is we have a table of planning permissions capacity, then trajectory 2179, and actual delivery. Do you see that?
Yes.
So we have a significant shortfall in actual delivery to 2023. Yeah.
Yes.
Okay. Now, just want to understand then what is going on in terms of those allocations, because if I look at table 3 below, I see that S2C, E, F, and G, I and J are complete.
Yes.
H is without planning permission, and we know what CD 5.9 had to say about that site.
Yes.
Okay. So what we're then left with is S2A, and we've got 606 and 394. Do you see that?
Yes.
With
yes.
But it's a reserved matter of 106. So I've got a reserved matter of 106 and a detail of 606, which is 702.
Yes.
So if actual delivery has been 481, how many homes does that leave me with which are consented? 712 minus 481. Sorry, I'm not sure that's quite right. I've got, so it says detailed permission for, are you doing this, Mr.? So you've got 606.
Yeah, I've got the 606.
And then you've got a reserve matter of 106, so that's 712.
Yeah.
And we've had actual delivery of 481.
Yes.
So how many are left to be delivered in terms of consents?
I'm happy for you to do the calculation.
Okay, well,
I haven't got mine on.
I'm wondering whether, to be honest, this is the best forum for this kind of questioning, to be honest, because I'm sure you'll appreciate, Mr. Cannock, that these are the re-examination points rather than asking the witness to undertake calculations.
Understood.
So I mean, it might be better if I'm more than happy, of course, for the figure to be worked out, and maybe it can be provided.
Well, I can put it in closing, so it's
I think to be fair to Mr. Armstrong, Sorry, I thought somebody's no. I think he putting him on the spot to do these calculations. I appreciate the point you're trying to make, Mr. Cannock, but probably best to deal with that maybe in closings.
I'm extremely happy for Mr. Cannock to put the number in closings, notwithstanding that it hasn't been said by Mr. Armstrong.
That was the only thing that was concerning me somewhat, is that it hadn't actually been in the cross-examination. So,
Just then, this is then the final question. If one looks at S2B, which is planning permission of 320 and should have delivered by 2022, what we're told in Table 3 is that outline permission was granted since 2020 and no reserved matters. So what confidence, if any, can we have that will deliver by 2029?
As I say, that site and others in there are I don't have an optimistic view, as Mr. Coleman does, about those sites delivering to basically complete their development by the end of the plan period.
Yeah, and the planning permission capacity, we're told, is 3373. But the 5-year supply is 1665. So does the local authority itself consider those sites are going to be delivered to 2028?
Now, they've obviously got concerns as well.
Yes. Thank you, sir. Those are my questions.
Thank you, Mr. Cannock. Much appreciated. Well, that concludes the evidence then of Mr. Armstrong and indeed the appellant's side. So the outstanding matters that we need to deal with are, and I'm not suggesting we do this now because I haven't had an opportunity to read the conditions in details, but we need to obviously have a roundtable discussion on conditions and on the obligation, which I think probably would be best done tomorrow. If that's
so, did you have any thoughts? I appreciate your focus has been elsewhere.
Yeah.
But did you have any thoughts about the need for a solicitor to attend?
Yeah, I don't think it will be necessary, Mr. Cannock. I mean, I had a brief glance at the obligation over lunch, and I think, given that the matters are not disputed, I don't think it's necessary. So, I mean, we'll work on the basis that we'll we'll open tomorrow at 10 o'clock and have a roundtable discussion on conditions and the obligation. I'm just wondering about closings. I mean, how far are you off in terms of preparing for closing?
I can close tomorrow mornings.
You could, right?
I could close tomorrow afternoon.
Yeah.
That I think we've made a nice early finish today.
Yeah. I mean, what I think I will do is I will have a think about the best approach and in terms of closings, but we'll work on the basis that we'll do the roundtables tomorrow morning, and I'll in consultation with you, Mr. Cannock, and Mr. Wilcox, we'll decide how we're going to approach the matter of closings. I think we agreed earlier that I could undertake a site visit unaccompanied, so that simplifies things in the sense that we don't need to have people involved with that.
One point I need to flag on that, sir.
Yeah.
Over the lunch break, two of the members of the public at the back approached me to extend to you an offer if you want to view the site from within their back gardens.
Right.
So you can see how it appears from settlements which are currently on the settlement edge. So whether or not that is an exercise that will assist is entirely a matter for you. It would, however, obviously if you're going to go into someone's dwelling, then it would, I think, create the need for, particularly if you're going to go into an objector's dwelling, I think in fairness to the appellant, that would require accompaniment.
Well, I mean, it always used to be the case, certainly at the planning inspectorate, that we were always accompanied in the past, but we do now have these mainly used in terms of written representation cases where we have what's called an access required site visit, which means that in fact it's just the inspector, but the inspector makes it clear that they can't discuss any pros or cons of the development. So I mean, I'm happy to proceed on that basis if
you're happy.
If the appellant's happy for that. As I say, it's an approach that's been adopted now for a good few years in terms of written representation cases that that in times gone by we always used to have the appellant and the counsel available, but now the planning inspectorate has worked towards a much more simplified approach where I think it's done all the time in terms of written representation cases. So I mean, obviously I'd need to let the individuals concerned when I was going to turn up. I mean, I wouldn't just turn up without letting them know. But I mean, if Mr. Cannock, are you happy for me to proceed on that basis? I make it clear to everyone now that I can't have any discussions about the merits of the case, and I won't be. If people start telling me how awful it is or how good it is, then I will just say, I'm sorry, I can't hear that now. So, Mr. Cannock, I don't know if you need to take instruction on that, or
no, I have done so. There's no objection for that. I would echo that. It does require a degree, respectfully, of self-control. But also you will be able to stand on the boundary because we have given you permission to access the site. So you could in any event stand on the garden boundaries, and it may be that that's an exercise that you want to do. But it's entirely up to you, sir, and we don't object to what you've suggested.
No, I mean, I think it's an accepted practice within the planning inspectorate now that we can undertake such visits unaccompanied. So I can proceed on that basis and advise the people concerned. It might be helpful if the council could provide me with the details of which properties it is that I'm being asked to view the.
I will see to it that that's done, sir.
Yeah, I think that would be very helpful. Okay, fine. All right then. Well, let's. We'll adjourn for the time being, and we'll resume again tomorrow then at 10 o'clock, if that's okay. All right. Thank you very much, everybody. Thank you.